All right, I am here with David Azizi of the Law Offices of David Azizi, and today we're going to discuss something as it relates to slip and fall injuries. We've gone over a lot of cases when it comes to slip and fall, but this is a situation we haven't really talked about, which is quite interesting because anyone who's worked in retail or worked at a grocery store or a Vons or a CVS or Walgreens or Rite Aid or Walmart, there are vendors that come in and often provide milk or bread or beverages, a Coke or Pepsi product, or maybe a alcoholic beverage with any type of those, Coors, Anheuser-Busch. And if that vendor comes in and they spill something and causes a slip and fall, who is at fault, David? Is it the store, the Rite Aid, the Walmart, the Target, or is it the vendor who brought in the bread or the milk or whatever? Who is at fault in that type of situation of a slip and fall?
Well, it could potentially be both parties who are at fault because obviously a owner of a premises has a duty and responsibility to make sure that the premises is safe from any dangerous condition. Now, by law, the premises owner says that we got a store, we have an inspection policy where we make sure that if there's any dangerous condition that it's either removed or warned until it's cleaned up or managed, so that if anybody comes across that dangerous condition, they can avoid it and not sustain injury. The vendor also is responsible because if they come onto the store property and they're transporting products, it could be a can of Coke, it could be, like you said, milk, any type of liquid, or anything that's a slippery substance or anything of that nature, or a box or a product that can cause somebody to trip and fall, and they cause that item, for example, to fall or spill on the floor of the market, whatever it would be, like you said, Vons, Rite Aid, whatever type of store it is, and that third-party vendor fails to either guard against that particular dangerous condition or provide notice or somehow clean it up, and somebody comes up along and either slips or trips and falls, well, then the argument can be you as a third-party vendor came in, you should have a policy and procedure in effect for you that maybe you carry a sign or something of that nature to where you guard that area, notify the store manager or whoever needs to be notified that there is this particular dangerous condition and it needs attention and it needs to be removed or fixed, whatever needs to be done to make sure that it's no longer posing as a dangerous condition. So that's basically, in a nutshell, what would be involved in a case like that.
Absolutely, and that's very important information, especially for anyone who may own a grocery store or a local retailer that you do take on vendors. Training your staff is extremely important, whether it be assistant managers or those. I know in a previous life when I worked in retail management, we were not allowed to leave the vendor under any conditions. We were to stand with them the whole time, which any large corporation knows the reason behind that. So if you have had a slip and fall injury or a trip and fall injury in a grocery store or anywhere in the state of California, please feel free to contact the law offices of David Azizi. You will see the phone number both above and below in the YouTube video, or you can go to davidazizipersonalinjury.com. Thank you for your time, David.
All right, thank you.